Here's a disclaimer from the Creditors in Commerce website. They ask that if you utilize their content from the website, that you also utilize the disclaimer. And basically, it's telling us that this is not legal advice, that we are responsible for our transactions and understanding what we're doing. When we take on any of the procedures, when we apply our remedy, we're responsible for understanding what we're doing. And this is also written in now time, in correct sentence structures, communication, parse, syntax, grammar. We've been trained, just as we've been trained to be debtors, we've been trained to speak and write in fiction, in past and future. Rarely do we write or speak in the now. And that's how this disclaimer is written, in the now. And on the Creditors in Commerce website, there is a link for the David Wynn Miller website where you can learn more about this. So let's get into trust. What is a trust? And this topic can seem daunting at first, but these particular 2 audios from this particular workshop make it very manageable, make learning about this topic very, very feasible. And it is an important topic because it helps to piece together some of the other knowledge that we have. So, what is a trust? A trust is a contract between parties. There are 3 parts to a trust. They are grantor, settlor, also trustor, and the trustee and the beneficiary. A trust usually describes the disposition of property. The property is the subject matter of the contract. A trust splits the title to property into 2 different entities. One holds legal title and one holds equitable title. The first party to the trust is the creator of the trust, known as the grantor, settlor, or trustor, and is the party that makes the offer to contract. The settlor furnishes the consideration for the creation of a trust, meaning transfers property into the trust. The trustor specifies the terms of the trust contract, also known as the trust indenture, which governs the conduct of the trustee and the rights of the beneficiaries. The second party to the trust is the trustee. The trustee holds legal title to the trust assets. And we'll define what legal title is as we go along. But the trustee holds the legal title to the trust assets. He or she is the one to whom the offer is made. The trustee accepts the responsibility of carrying out the terms and conditions of the trust contract and is the protector for the property that is put into the trust, which is the collateral. The third party is the beneficiary, who is the equitable title holder. And we'll define what that is as we move along. But the beneficiary is the one that gets the use of and or possession of the property in the trust. That's what equitable title means. It means a beneficial interest in the trust. It means use and or possession of the property. And here is a diagram of a trust setup. At the top we have the grantor, the one who creates the trust, furnishes the property, furnishes the funding for the trust. They choose a would-be trustee, somebody they think they can trust, who will carry out their wishes per their contract. Trustees at the bottom left-hand corner. And then on the right you have the beneficiary, the one to whom all this property will go to, who has the right of use and possession of it, according to the terms in the trust indenture. And because it's a trust, that means there's split title, so there's different interests. The grantor has a capital interest in the trust, the trustee has a controlling interest in the trust, and the beneficiary has an equitable interest in the trust. The trustee will issue two types of certificates. One is a certificate of beneficial interest, showing equitable interest in the property which goes to the beneficiary. The trustee will also issue a certificate of capital interest, which is the grantor's certificate, showing a controlling interest in the property and the trustee under the indentures of the trust / the trust contract. The trustee is serving as the legal title holder because the trustee controls the property and distributes any benefits or equity to the beneficiary. An important note, the same entity cannot hold both legal and equitable title for it to be a trust. If the same entity holds both legal and equitable title, then it is not a trust. For it to be a trust, an entity must hold either one or the other. Trusts can be layered inside one another. A court case, for example, is a constructive trust inside the state of New York trust, inside the United States trust. A trustee of one trust can be the trustee of another trust. And each party to a court case is operating 2 or 3 trusts individually. And we'll see how that is as we move along. So here we have, side by side, the private trust and the public trust. These are characteristics of the public and private trusts. Important to note that neither is a real man or woman, right? Both of them are titles. As you can see in the private trust, the name is in uppercase, lowercase. In the public trust, the name is in all capital letters. Both of those are just titles, labels. Neither of them are us. So let's go over the private trust first, because you can't have the public trust without the private trust existing first. So in the private trust is the realm of the republic. In the private trust, the uppercase, lowercase name is the natural person. It is the certificate of live birth entity. It is the trustee of the public trust, the controller of the public trust. The name appears, again, as I said, in uppercase, lowercase. And the private trust operates under the law of the land. The private trust is induced by the mother's application for the birth certificate. So the private trust is not the birth certificate. It is evidenced by the birth certificate, but it is induced by your mother's application for a birth certificate. It is created on your behalf. As I said, evidenced by the birth certificate. Your entire estate is pledged to the national government for repayment of the national debt. In the republic, in the private, you are the controller of what will be the public trust. It already is, but from where we're standing looking at just the private trust, what will be the public trust, you are the controller of that. I am the controller of that. Because the government, USA Incorporated, pledged our entire estate, which we'll define estate later on in the presentation, but for right now, so you have an idea, your estate is pretty much every interest you have in you. It is your body. It is your lifetime's worth of energy. It is everything you will accumulate in this lifetime. Everything you think you own. All of that is pledged to pay the national debt. It is monetized. But in the Republic, we operate as creditors. So we have remedy, right? So they took away our estate, the entirety of it, but they did give us remedy. And we'll get into that later. So that's the private trust. In the public trust operates as a democracy. In the public trust, the name appears in all capital letters. It is the artificial person, the straw man. And that name is the beneficiary of the public trust. The public trust operates under admiralty law, maritime equity law, and it is the resulting trust of the contract between the private trust and the United States corporation. It is a joint venture between the all capital letter name and the uppercase lowercase name. The artificial person, the straw man, the beneficiary of the public trust is a U.S. citizen, which equals voluntary servitude. It is a debtor of the bankrupt United States of America Corporation. The public trust corresponds with the private trust. The beneficiary is your straw man, and he receives all public benefits to sustain life. In the public, they never recognize you as a living man or woman. In the public, everything that comes to you or from you goes through the straw man corporation, goes through the beneficiary. But they had to create that entity, the straw man, in private international law by contracting with your private trust. They are a parallel, and the private trust must work in harmony with the public trust. And here is an illustration of what we just went over. So the top part in black and white is the private trust, the law of the land, the republic. The bottom is the public trust law that operates on the law of the high seas, the laws of commerce, and it is the public trust, the democracy. So the first party to the first trust, which is the private trust, is the grantor, which is your mom or dad, the living man or woman who applied for a birth certificate. When you look up the words submit and apply in the law dictionary, they kind of mean something different than you probably might think they do. Apply, we define it later on here, but apply means to request, to petition, to ask. And when you look up petition, that's an interesting definition. In that definition, it says a prayer, an asking, a requesting, or a prayer to some other authority to give you something, to grant you some privilege, some benefit, or to correct a wrong for you. Like we're saying, I can't do this myself, so will you please give me something? I'm looking to you as an authority. Will you please give me something? And that's an offer to the state. That's an offer. So they accept, and poof, a trust comes into existence. So your mom or dad submits an application for the birth certificate. The state accepts the offer, and here now exists the trust, which is the certificate of live birth entity, which is your uppercase, lowercase name, the creditor, the trustee of the public trust, whose remedy is H.J.R. 192. The beneficiary of the private trust, again, because we're dealing with a company that's bankrupt, so the beneficiary of the private trust is the Secretary of Treasury of the United States of America Incorporated. The Secretary of Treasury now has the use and possession of our entire estate. Again, our bodies, life's worth of energy, any and all property we accumulate, that is now going to the beneficiary, which is the Secretary of Treasury of the United States. That estate, our estate, gets funneled now into the public. The United States Incorporated can now create a trust in the public, utilizing our estate to fund it, to fund the public. So in the democracy, the grantor is the Federal Reserve banking system, which is a private company also. It's just two businesses doing business together. United States of America Incorporated is a company. Federal Reserve banking system, Federal Reserve Bank is a company, and they're doing business together. Okay, so Federal Reserve banking system is the grantor, the creator of the trust. The trustee is any and all public officials, cops, attorneys, Anybody who's sworn an oath of office and is a public official is a trustee of the public trust. The beneficiary of the public trust is the fictitious corporate strawman, your all capital letter name. Still not you. And these three little boxes pointing from the Secretary of Treasury, that stands for Federal Reserve Bank, Depository Trust Company, and Internal Revenue Service. So why did the de facto United States government induce you to become a trust? First, it's helpful to note that the United States government is not actually a government like most assume it to be. The United States is a company, a corporation. United States of America Incorporated is a legal fiction operating in commerce and bankruptcy for profit under limited liability insurance. It is a business. U.S. citizens are employees of the corporation and subject to the bylaws of the corporation known as United States statutes, acts, codes, rules, and regulations. Continuing on with the why. The why did they induce you to become a trust? It's because the United States is bankrupt. In order to borrow money through loans from international bankers, and I'll interject right here because why would they need to get loans from international bankers? Well, the reality is that we are the creditors, we're the controllers of the public trust, but we haven't been acting that way. The majority of folks in America don't even know about this, let alone are they acting like the creditors that they are. We're not funding the public as we could be. So they got to go get money from somewhere else. They have to go seek out some other creditors who will extend them credit because the people of the nation aren't doing it. We could be. So anyway, that's why in order to borrow money through loans from international bankers, United States of America Incorporated had to put up collateral. Sureties had to be put in place to secure payment to the creditors of the bankruptcy. After all the land of America was pledged as surety, the only thing left for the bankrupt United States to pledge was its citizens. This is not the first bankruptcy. I'm referring to the early 1930s, where there was a bankruptcy, but that's not the first one. So by the time that bankruptcy took place, the only thing left to pledge was the people on the land. Their property, including their own bodies and their lifespan's worth of commercial energy, is pledged as surety for the national debt. What is surety? Surety is a person who assumes legal responsibility for the fulfillment of another's debt or obligation and himself becomes liable if the other defaults. Security given against loss or damage, and a guarantee that an obligation will be met. Surety is one who has contracted to be responsible for another, especially one who assumes responsibilities or debts in the event of default. Some other words for surety are pledge, bail, security. So we've made ourselves liable for the debts of United States of America Incorporated. And when USA Inc. defaults, we become responsible for that. The debt doesn't just go away. Somebody is responsible for taking care of it. The Federal Corporation USA Inc. wanted the collateral, your estate, registered with whatever state issued you your birth certificate. Let's use New York State, for example, where mine is issued from. My strawman's certificate is issued. The Federal Corporation wanted the collateral all of my estate registered with the state of New York, based on the constitutional provision that the state would have to share the assets with the national government to set off the debt. By our relationship with the state, by my relationship with New York State via the filing of the birth certificate, New York State could carry my estate into a beneficial interest to help underwrite the national government. Estate is defined as the degree, quantity, nature, and extent of interest in which a person has in real and personal property. This includes your body, your energy, any and all other property you think you own, even your children if you've registered them through the birth certificate or have a marriage certificate. All property, our life's energy and body. And this is a quote from Jack Smith, who spoke a lot on these audios. He might have done most of the teaching regarding this topic. Brandon shared a lot and Gordon shared a lot, but Jack seemed to be sharing the most regarding this particular topic. And he said this. He said, "They are buying and selling the souls of man. All these estates represent the gifts God gave us, and they are buying and trading those as securities." And that, my friends, is a typo. It says the workshop 2012. It is actually the workshop from 2010. Legal title and equitable title. Legal title is control over the property. Whoever holds legal title makes the rules and regulations for its use and or possession. Equitable title is right of use and possession. Whoever holds equitable title can do what they want with the property, so long as the use and possession is within the boundaries of the rules that are set forth by the legal title holders. Using a registered car as an example, let's identify which entity holds legal title and which entity holds equitable title. So here's a scenario. You go to the Department of Motor Vehicles, your local one, and apply for registration or tags, whatever you call them in your state. Let's look at apply. What are we doing when we apply for something from the state, for the state to grant us something? What are we doing? Well, apply means to make a formal request or petition. Request is an asking or petition. Petition is a written address embodying an application or prayer from the person or persons preferring it to the power, body, or person to whom it is presented for the exercise of his or their authority in the redress of some wrong or the grant of some favor, privilege, or license. So we can say that we're putting out a prayer to New York State for New York State to exercise their authority in the granting of some favor to us. Like I'm saying, I don't have my own authority. I need you to grant me something. I need you to give me something. So that's what we're doing. So what just happened? You took the title to the car, to the DMV, and applied for your car's registration. In applying, you were asking, requesting, praying for another's authority to grant you a privilege, a benefit, in this case, your registration or license plates or tags. This was an offer you made, and I don't say you like you because I've done it too. When we do that, we are making an offer to the state. We're making a proposal to the state through the act of submitting the application that we filled out, of granting them legal title. We are making them a proposal, saying, here, take controlling interest in the car, and in exchange, I'll take benefits and privileges for my straw man. So the state accepted and granted you your plates and your proof of registration. They accepted. Now you have a trust. Now the car is held in trust. Your straw man is now part of a trust, and the car property is now held in that trust. The state has controlling interest, legal title, and the car is now added to the surety pool that secures the national debt. The entity that issues a certificate is the legal title holder. The entity named on the certificate is the beneficiary and is the equitable title holder. The state, New York State for instance, issues you a certificate of title because New York State is the trustee, the legal title holder, and your straw man, the entity that the state contracted with, is the beneficiary. Remember, the state contracted with your public trust, the all-capital letter name. The legal fiction that you do commerce with, and it's your straw man that holds equitable title, evidenced by the certificate of title issued to you by the trustee. Because you issued a grant to the state for them to be the legal title holder, all their statutes involving the ownership and operation of the motor vehicle are the trustee's rules for possession and use of the automobile. So the Motor Vehicle Act is the trustee's rules for possession and use of the automobile. It's important to understand that the straw man corporation is the beneficiary of the public trust, not the living man or woman, because everything involved in the trust deals with titles and nobility, and it is all fiction. The parties are just playing roles. The state creates all the rules for the use and operation of the vehicle. You have consented to it by a contract. When you register anything with the state or federal government, it is placed in trust, and a grant is made to the state. Again, let's recap. Copy number 1 of you having a name similar to yours, uppercase, lowercase, natural person, certificate of live birth entity arising out of the mother's application for a birth certificate. It is the trustee. You are the trustee of your private trust. You are the controller of the public trust in a way because you fund the public. So your control is in the private. Copy number 2 of you, also having a name similar to yours, is the uppercase, all uppercase, Jane Doe. The straw man, the artificial person, the birth certificate entity, beneficiary of the public trust, arises from the contract between the United States Corporation and your private trust. It was a voluntary act, and now the straw man enjoys beneficial use. You know what? I want to make a correction because I just said that we are also the trustee of the public trust, and that's not true. Only public officials are trustees of the public trust. We can't be seen in the public because we're real living men and women. But we are the trustee of the private trust. And because the public trust arises out of the private trust, we can control the funding of the public trust. We do, actually, because all of our estate is pledged. But we haven't been doing a very good job. We haven't been controlling it. We've just been leaving it to the wind. And so U.S. Inc. has to go get money from other creditors because the people of the nation won't step up and be creditors. So I just wanted to make that distinction there. So it was a voluntary act, and now the straw man enjoys beneficial use as long as he stays within the boundaries of the trustee's rules and regulations regarding the property. Another note, the legal title holder, the state, does not have the right to possession as long as the equitable title holder, your straw man, is following the rules with regards to anything dealing with the collateral, car. The state does not have the right to take the car. 9/10 possession is the law. So why do we get pulled over? Because the state has legal title. The cop is an officer of the state. He's a trustee. They are investigating what we are doing with regard to the property that was donated to the state. They want to know if we are in line with their rules and regulations for the operation of state property. This is part of their function, and we voluntarily agreed to do it. If it is land and you have both legal and equitable title, it is called allodial property. Having allodial property means that there is no government land tax to be paid. Why would you pay a tax to the government if you have both sides of the title? The fact that you pay a property tax shows that you don't have both sides to the title. Again, the title is split. When it is split, it is said to be owned in a trust, not through one entity.